matter, okay, as far as your authority to rule. As far as the substantive merits of Mr. Werdeman's motion to disqualify, I'll try and be brief, but basically the petitioners have it wrong on the law and they have it wrong on the facts, and there is no basis to disqualify. First, as Mr. Werdeman has reminded us, we should follow the law as laid down by the Hawaii Supreme Court, and the Hawaii Supreme Court cases in this matter, along with the law that has been passed by our legislature and is in the statutes, shows that the petitioners, if you want to try and disqualify an attorney, you have a very heavy burden. Nobody's trying to disqualify Mr. Werdeman. If you're trying to disqualify an attorney that somebody else uses, whether it's the tribunal's counsel or somebody else, you have a heavy burden because there's a potential for gamesmanship and abuse. And the courts, including the Hawaii Supreme Court, on numerous occasions have ruled that that you have to make particularized showings in order to do that. The law on disqualification is different from what Mr. Werdeman cites. Mr. Werdeman ignores the law that says the Attorney General shall represent the BLNR and shall represent the hearing officer. That's the HAR. Mr. Werdeman ignores the law that says that normal conflicts of interest do not apply to the Attorney General or the Department of the Attorney General. That's the Clattenhoff case and the Inree Water case. And Mr. Werdeman ignores the Hawaii Supreme Court case that is right on point, which is the White versus Board of Education case that says the tribunal's attorney at times should step back, but if and only if it is the same Deputy Attorney General on the same matter who acted in an adversarial role. In this case, what we have is the Deputy Attorneys General and the Department of the Attorney General and the Attorney General himself have only acted not in an adversarial role. They have not tried to be a prosecutor. They have not taken the side of anybody. They have solely and always, on the record, represented only the BLNR and only the hearing officer.
Here, who are the adversaries in this case?
In this case, you have a contested case that is coming forward, okay, and there is a question that has been brought forward by the petitioners that has been raised.
Adversaries are essentially the University of Hawaii at Hilo.
Yes.
Seeking a permit.
Yes.
We have Mauna Kea Anaina Ho opposing the permit.
That's correct.
We have a number of interveners who wish to participate and for which I found their assistance would be helpful to me, I hope.
That is correct.
And those, I think, are the adversaries. And I don't include that the Department of Land and Natural Resources or the Board of Land and Natural Resources as an adversary. So if the AG's office was in fact representing BLNR, then they're not in an adversary relationship with these parties. Is that
correct.
Is that your thinking?
That is my thinking. That is my analysis. So my point is that the petitioners are wrong on the law here. They're trying to set forth an incorrect standard. It doesn't apply. If we follow the teaching of the Hawaii Supreme Court, then it's clear that there is no disqualification. And they're also wrong on the facts because they've raised these emails and they've tried to suggest that somehow the Department of the Attorney General is in cahoots or in a conspiracy with the University of Hawaii or TIO because there were some emails that were talking about the closure of the road. Many people remember the closure of the road, and that came up. And there were some emails. But the emails go to the preservation of health, safety, and welfare. The whole point of that road closure exercise was that there was a concern for safety and welfare up there. When you start obstructing traffic, and this happens in labor disputes, this happens when people's passions run high, it can happen, but it raises, when people want to stop traffic and block traffic and they want to protest, they're allowed to do that, but it does raise issues of health, safety, welfare, and proper order. And that's all that the Attorney Generals in this case with these emails were doing. And so that, in my view, is, if they're, to the extent that they're trying to show that the individual attorneys general here were acting on behalf of TIO or acting on behalf of the UH, that's just wrong. They're wrong on the facts. That the emails do not go that far. So for all of those reasons, Judge, I believe that you can rule, you should rule, you have the power to rule, and the power to deny this motion. The motion is wrongly brought, it's wrong on the law, and it's wrong on the facts. Thank you.
Thank you, Mr. Louie. Mr. Wardeman.
With respect to the deputy attorney generals in this case, you know, they were on the opposite table from me, both in the Third Circuit and also in the Supreme Court. They were adversaries. And they argued. Although the court didn't reach it in its decision because it stopped on a due process issue, they argued, and I attached a brief to my motion, that the University of Hawaii had met all of its elements. The 8 criteria under the Hawaii Administrative Rules in issuing a conservation district use permit were met by the University of Hawaii. They briefed that. They coordinated with the University of Hawaii Council during all of the litigation on filings, and it's attached in my emails. So what we're asking for is that, consistent with the Supreme Court's decision, is that on remand, that a fair and impartial hearing officer be given fair and impartial advice from a fair and impartial advisor. And that's what this whole motion is about. And it's clearly consistent, we believe, with the Supreme Court's mandates on remand. Mr. Louie had also cited some cases. I mean, in footnote 7 of the White case that he cited, this is a Supreme Court case way back in 1972, it says, in cases of this nature where the board requires legal advice in its decision-making function, it should call in another deputy attorney general who had no part in the adversary hearing. I mean, he cites the case. I'm just telling you, reading to you the footnote from the case he cites. He talks about the Kila Kila case. First of all, that's a memo opinion. That doesn't have any precedential value, but even more so, the Kila Kila case, the Supreme Court granted cert. So that case is before the Supreme Court. They obviously believed that there was some merit to the issue that the Kila Kila appellants in that case said that the ICA committed grave error, because that's the standard by which the Supreme Court grants cert petitions. And that's still pending before the Hawaii Supreme Court. So I mean, this, and the case that is cited in there, it was a similar proceeding, and talked about in footnote 6 in that case, but it's not a situation like we had here, where Mr. Weinhoff and Ms. China were actively taking an adversarial role on the issues that are before you in this case, the same issues, with perhaps a lot of the same arguments, a lot of the same evidence, and they've already argued for that before in the appellate process, and that's what our concern is. It's the coordination that took place with UH, and then in the third set of examples, you know, they were involved in group emails, and apparently from the emails, telephone conference discussions with Mr. Ng, Mr. Louis Kwan, and Mr. Sanderson, Mitch Roth, the county prosecutor, and his deputies, Ms. China, Mr. Weinhoff, and what all of that was about was how do we go about arresting and prosecuting and coming up with, and I think Mr. Ng's partner at one time even provided a legal memorandum to the various parties. Again, all of this stuff was going on. Mr. Weinhoff, China, and I believe Ms. Chow were also involved in. And it involved the arrests and attempts at prosecution at some of the parties in this case. So these counsel, including one of my clients, and I'll represent to this hearing officer, one of my clients was arrested, a member of the Flores case, Ohana, after Mr. Chin went before the land board and made this big presentation about emergency rules in dealing with protectors up on Mauna Kea and how to get them out of the way. Mr. Chin argued all of that. The board passes it with 2 opposed. One of my clients gets arrested pursuant to that passing of the emergency rule, and this appears to be what I attached in my pleadings, this home run that they found, that they were talking about. This appears that this coming up with this idea of emergency rules was this home run that all of these parties were talking about on how to take out some of these parties and my client from these proceedings. And these advisors, who are supposed to be fair and impartial, participated in that. It's really disingenuous for the other parties to somehow think that it's just something we can just simply sweep under the rug, because there's no way, based on the adversarial positions taken going up to the Supreme Court, there's no way that, and we would take it a step further based on Mr. Chin's participation throughout these, working through all these issues. But this is a matter that the Governor Ige himself had talked about first and foremost in his last State of the State address. I mean, that's how significant it is to the Ige administration. And we're still trying to get certain emails in our 92F requests to get more concrete evidence. But this really rises to the level of a case that's really not been seen before, because of the political charge in this case, the significance of Mauna Kea, the significance of the construction on Mauna Kea, the significance of all the parties involved, the significance of the governor taking a position, and obviously that pressure carrying on to other cabinet members, including his attorney general and his chair of the board. The message is clear from the governor and his position what needs to be done in this case. And that political pressure is there. Again, the adversarial nature of their participation is there. And I think that the only proper recourse is for disqualification. If we're going to give the Supreme Court's decision any consideration whatsoever. And why? I mean, why not do the right thing? I mean, it may not be convenient. But, you know, due process is not about convenience. It's about doing what's right. And
In all of the matters that you cited relating to the deputy AGs giving advice to folks or interacting in whatever way, weren't they acting as counsels to clients like the Department of Labor or BLNR? They themselves were not the adversaries.
they were certainly, and during the appellate process, they were advocating for a position and trying to find out how to get people arrested and prosecuted, and they engaged in that.
Well, they were advocates for a particular client and giving advice to that client. Isn't that true? No? They themselves were not parties or advocates.
Frankly, I'm shocked.
Rather, adversaries.
Frankly, I'm shocked that they even participated in any of those. I mean, I think the ethical and proper thing would have been to let the county prosecutor do his job. It would have been to have UH and TMT stay out of the process and trying to influence. I mean, I think that's ethical problems for the county prosecutor as well, to be listening to these entities in trying to, and providing him legal advice and legal memos. You know, a lot of people were hurt up there. I mean, it's not fun to get arrested.
I don't know much about what happened up there, and I honestly don't know about the emergency rule and all those things, so all the information you're giving me is new, and it does sound to me like people were pretty zealous, but as it relates to this contested case hearing and whether or not a permit should issue, you know, this is where I think it's pretty black and white. I know that, as you say, some of the parties might be the same, but the issues are so distinct.
I think because of, well, they're essentially the same issues on remand. Consideration of the 8 factors of the Conservation District use permit and how.
But that doesn't have to do with the emergency rule or all that other stuff about arrests.
Right, but one of my clients were arrested. These same attorney generals were involved in that as far as the dialogue went. I mean, how can I mean, I think it's just clear cut that there's no way that anyone can be fair and impartial at this point when they've taken such a harsh position against my clients that turned out to be wrong. Judge Ibarra threw that emergency rule out. He said it was illegal. And thank goodness for the court, because if it wasn't for the Supreme Court, there would have been a lot more arrests going on and bulldozers up there, and we wouldn't be before you today. But the Supreme Court made it clear, and again, on the adversarial role that the board took in arguing that the criteria had been met by the UH, coupled with their coordination during litigation, I mean, they clearly took an adversarial role. And that in and of itself, and consistent with the Hawaii Supreme Court decision in Mauna Kea Naiho, warrants and requires disqualification of such counsel. Thank you.
All right, thank you, Mr. Werderman. On document number 95, this hearings officer will take that matter under advisement and issue its decision. I'd like to take a 10-minute recess. It is now 3:15, so please return at 3:25. I forgot to mention earlier.